Here are all of the topics covered in the US pressure groups revision video. This video will focus on the methods used by pressure groups, looking exclusively at how the courts are used. Due to the way that US government operates, there are many different areas for pressure groups to access, and therefore have some degree of influence. There are 50 state governments and legislators, in addition to federal government, along with Congress and the Supreme Court. Pressure groups can choose to work at either state or local level, as well as both. They may also choose to target the executive, the legislative, or the judiciary branch, or all three. In order to do this, pressure groups wield a wide range of different methods to try and influence decision making. Another method used by US pressure groups is using the courts. Many pressure groups try to achieve their aims via the courts. This can be a very productive strategy because the Supreme Court has so much power to interpret the Constitution and to check the power of the executive. Let's start by legal challenges. Pressure groups can target an area of the law where they wish to see a change and support cases that hinge on this point. They may lose in the lower courts, but then appeal the case all the way up to the Supreme Court, where they hope for a landmark ruling, a transformative change to the law, which accomplishes the pressure group's main objective. Pressure groups that have successfully used this strategy include the following. The NAACP funded Brown versus Topeka in 1954, in which the Supreme Court decided that the doctrine of separate but equal was unconstitutional. And the ACLU brought the legal case of Obergefell versus Hodges in 2015. The Supreme Court's ruling on the case legalized same-sex marriage across the US. Legal challenges can target state laws that are aimed at eroding a previous ruling by the Supreme Court. Health provider and non-profit organisation Planned Parenthood has brought many cases together to defend the abortion provision of Roe v. Wade. In Planned Parenthood v. Casey in 1992, the organisation filed a suit against the governor of Pennsylvania for enacting abortion restrictions based on the legislation passed by the state legislative. The right to abortion was upheld and one of the restrictions was struck down, although the rest was allowed to stand. In 2019, the organisation brought legal cases against the highly restrictive laws in states including Alabama, Georgia, Indiana, and Ohio. Pressure groups can also hold the executive to account by challenging its actions in the courts. For example, the ACLU mounted 56 legal challenges against Trump's administration from 2017 to 2018, including the following. Trump's ban on immigration from a number of Muslim-majority countries was halted by a federal court in 2017. As a result, he modified his ban to include several non-Muslim countries, and it was upheld by the Supreme Court in 2018. The ACLU also challenged Trump's 2017 ban on transgender people in the military. This was initially halted by a federal court, but the Supreme Court allowed it to proceed in 2019, while further legal challenges took place. Another method is amicus curiae briefs. Pressure groups often submit information to court cases with the hope of influencing the outcome. They do not need to be involved in the case in any way to do this, and can involve lawyers to write amicus curiae briefs on their behalf. These briefs set out specific evidence or research that the pressure groups hope will influence the justices. Amicus curiae briefs can also be submitted by academic legal experts, the executive, or anyone else who has an interest in the case. Let's look at the impact of amicus curiae briefs. It is impossible to know exactly how much impact these briefs have on the decision-making process of justices, but the number submitted has increased in recent years. In the 1950s, the average Supreme Court case received just one amicus brief, whereas a record 16 briefings were submitted per case in 2019 to 2020. More briefs are also given to landmark cases, such as Brown versus Topeka, which had 6 amicus briefs, but a record 148 were submitted for Obergefell versus Hodges. Some amicus curiae briefs clearly influence the decision-making process, as justices refer to them in their written opinions on cases. In American Legion versus American Humanist Association in 2019, the Supreme Court ruled that a specific war memorial in the shape of a cross was constitutional, and Justice Ruth Bader Ginsburg quoted from the amicus brief submitted by Jewish war veteran of the United States of America to support her dissent against the court's ruling. There is an argument that the use of amicus curiae briefs is elitist. Amicus curiae briefs can give a voice to sections of society, such as Jewish war veterans in the previous example, who might otherwise be overlooked by the courts. However, amicus briefs are more likely to be cited by justices if they are written by legal experts. This favours pressure groups with specialist legal expertise and extensive experience of preparing amicus briefs, such as the ACLU and the National Association of Criminal Defence Lawyers, the NACDL. Writing an amicus brief is an expensive process, which has led to criticism that wealthy pressure groups are able to use this method more effectively than others. In an attempt to increase transparency, rules state that financial contributions to the brief must be published. Some pressure groups have used crowdfunding to fund their briefs. While this does offer an opportunity for less wealthy pressure groups, this new method of funding is not without problems. In 2018, the Supreme Court rejected a brief by the US Alcohol Policy Alliance in 2018, as some of the crowdfunding donors were anonymous. Let's look at a case study for using the courts. The case study is going to be Planned Parenthood versus Casey. Planned Parenthood versus Casey in 1992 was a landmark US Supreme Court case regarding abortion. The court upheld the constitutional right to have an abortion that was established under Roe v. Wade in 1973, but altered the standard for analysing restrictions on that right, creating the undue burden standard for abortion restrictions. In the case, Planned Parenthood filed a lawsuit against the Governor of Pennsylvania for enacting abortion restrictions based on legislation passed by the same state legislature. The right to an abortion was upheld. It was considered a landmark case as it was the first case to provide an opportunity to overturn Roe v. Wade since two liberal justices had been replaced with conservative ones.